us all rise for the arrival of the Honorable Senate President and the Senators of the Republic of the Philippines.
The 49th session of the Senate in the first regular session of the 18th Congress is hereby called to order. Senator Pia Cayetano will lead the chamber in prayer.
Let us all put ourselves in the presence of the Lord. Heavenly Father, amidst the peril that haunts the world today, we ask for your continuous protection. We remember your holy words from Isaiah 41:10. Do not fear, for I am with you. Do not be dismayed, for I am your God. I will strengthen you and help you. I will uphold you with my righteous right hand. We take comfort in these holy words as we continue to pray for the safety of our entire nation and the world. As social media has given us the means to have information at our fingertips, give us the wisdom to filter the right information from the wrong ones. Give us the humility to listen to the real experts and different opinions, and to even be able to undertake an unpopular route if that is the right one. All of this we lift up to you, O Lord. Amen.
Amen. Senate choir will lead us in the singing of the Philippine National Anthem, and then the group will also render a song entitled Ako'y Pilipino.
Bayang magiliw, pero sa silanganan, alam ng puso, sa dibdib mo'y buhay. Lupang hinirang, duyan ka ng magiting, sa manlulupig, di ka pasisingin. Sa dagat at bundok, sa simoy at sa langit mong bagaw, may dilagang tula at awit sa paglayang minamahal. Ang kisap ng watawat mo'y tagumpay na nagdidindig, ang bituin at araw na kailan pa may di magdidilim. Lupa ng araw ng buwan at ipagsinta, buhay langit sa piling mo. Aming ligaya ng pag may mga api, ang mamatay ng dahil sa'yo.
The Secretary will please call the roll.
Roll call of members, the Honorable Senators Angara, Binay, Cayetano, De Lima, De La Rosa, Drilon, Gatchalian, Go, Gordon, Ontiveros, Lacson, Lapid, Marcos, Pacquiao, Pangilinan, Pimentel, Po, Recto, Revilla, Tolentino, Villanueva, Villar, Zubiri, Senate President Soto III.
With 22 senators present, the chair declares the presence of a quorum.
Mr. President?
Majority Leader.
Yes, Mr. President, just for the information of our colleagues who were not in the meeting earlier at 1:30 this afternoon, we'd just like to inform, with your permission, Mr. President, we'd just like to inform the body and all the staff, together with our colleagues, that we will be implementing stricter health protocol or stricter protocols on visitations due to the outbreak of the coronavirus all over the world with that alarming contamination rate. The Senate majority and minority had agreed to implement stricter protocols on visitations, especially those seeking financial assistance due to health requirements, as well as asking our colleagues that to limit visits to official matters, Mr. President, just for the information of the body.
All right.
And if there are questions, of course, by our colleagues who were not able to attend the meeting, they can approach either myself or the Senate President.
Yes,
for
thank
the
you.
protocols.
Thank you, the Majority Leader. We will issue an official memorandum to this effect
Yes, that's correct, Mr.
within the
President.
day.
And I believe I spoke earlier also, Mr. President, to members of the House of Representatives headed by Speaker Allen, and Speaker Allen said that they will also do the same protocols, Mr. President. So it's not just one house of the legislative body, but both houses, so that we just make sure that we don't add to spreading the disease in our country, Mr. President.
Yes, this is what we call precautionary measures.
Precautionary measures. Temporarily, Mr. President, until we can find, until we see a light in the end of this very dark tunnel of this coronavirus problem. Mr. President, without doubt, before we move to other matters, we just like to recognize the daughter and chief of staff of the Bangsamoro, the BARM speaker, Mr. President, Attorney Pangilinan Balindong. She's with us, the chief of staff, Mr. President.
Welcome to the Senate.
Mr. President, I move that we, with the permission of the body, dispense with the reading of the journal of the 48th session, Wednesday, January 29, 2020, consider the same as approved. So,
Any objection? Hearing none, the journal is approved.
Mr. President, I move that we proceed with the reference of business.
Secretary will proceed with the reference of business.
Reference of business, bills on first reading. Senate number 1300 entitled An Act Protecting Individuals from Mixed Filipino Heritage from Discriminatory Acts, introduced by Senator Tolentino.
Refer to the Committee on Women.
Senate number 1301, an act institutionalizing government support to gifted, talented students, appropriating funds therefore and for other purposes, introduced by Senator Tolentino.
To the Committees on Basic Education, Higher Education, and Finance.
Senate number 1302, an act mandating the installation of gray water treatment systems, facilities in buildings and imposing penalties for violation thereof, introduced by Senator Poe.
Refer to the Committee on Public Works.
Resolutions, PS Resolution number 303 entitled Resolution Directing the Proper Senate Committees to conduct an inquiry in aid of legislation on the implications of the termination of RP-US Visiting Forces Agreement, introduced by Senator Binay.
Refer to the Committees on Foreign Relations, National Defense.
PS Resolution number 304, resolution congratulating and commending Heidelin Diaz for successfully dominating the 2020 Roma Weightlifting World Cup with 3 gold medals on 28 January 2020 in Rome, Italy, securing for the country a spot in the 2020 Summer Olympics in Tokyo, Japan, introduced by Senator Zubiri.
To the Committee on Rules.
PS Resolution number 305, resolution expressing the sense of the Senate, the termination of or withdrawal from treaties and international agreements concurred in by the Senate shall be valid and effective only upon concurrence by the Senate, introduced by Senator Drilon.
Refer to the Committees on Foreign Relations and National Defense.
PS Resolution Number 306, resolution expressing the sense of the Senate that the validity and implementation of the Visiting Forces Agreement between the Republic of the Philippines and the United States of America should be urgently reviewed, introduced by Senator Marcos.
Refer to the Committees on Foreign Relations and National Defense.
PS Resolution Number 307, resolution urging the appropriate Senate committee to conduct an inquiry in aid of legislation on garbage imported into the country with the goal of formulating policy interventions to resolve garbage importation issues, introduced by Senator Cayetano.
To the Committees on Environment and Foreign Relations.
PS Resolution Number 308, resolution declaring 2020 as the Sustainable Development Goals Decade of Action, introduced by Senator Cayetano.
Referred to the Committee on Sustainable Development Goals.
Communication. Letter from the Office of the President of the Philippines transmitting to the Senate two original copies of RA number 11468 entitled An Act Designating the third Sunday of November every year as the National Day of Remembrance for Road Crash Victims, Survivors, and their families, which were signed by President Rodrigo Roa Duterte.
To the archives. There is additional reference of business.
Additional reference of business, bills on first reading. Senate number 1303 entitled An Act Establishing the Science for Change Program, introduced by Senator Lacson.
Referred to Committees on Science and Technology and Finance.
Senate number 1304, an act amending Articles 14, 19, 124, 211, and 225 of Executive Order number 209, otherwise known as the Family Code of the Philippines, introduced by Senator De Lima.
Referred to the Committee on Women.
Senate number 1305, an act amending Section 9 of Presidential Decree number 651 entitled Requiring the Registration of Births and Deaths in the Philippines, which occurred from January 1, 1974 and thereafter, introduced by Senator De Lima.
To the Committee on Justice.
Senate number 1306, an act redefining the mandate of the Public Attorney's Office, PAO, amending for the purpose Republic Act number 9046 and pertinent provisions of Executive Order number 292, otherwise known as the Administrative Code of 1987 as amended, and for other purposes, introduced by Senator De Lima.
Referred to the Committees on Justice and Civil Service.
Senate number 1307, an act redefining the crime of syndicated estafa, amending for the purpose Section 1 of Presidential Decree number 1689, introduced by Senator De Lima.
To the Committee on Justice.
Resolution. PS Resolution number 309 entitled Resolution Directing the Proper Senate Committees to Conduct an Inquiry and Assessment in Aid of Legislation on the Visa Upon Arrival Policy for Chinese Nationals with the end in view of ensuring that the Visa Upon Arrival scheme would not pose health risks and facilitate the proliferation of sex trafficking and prostitution in the country, introduced by Senator Binay.
Referred to the Committees on Foreign Relations and Women. Majority Leader.
Thank you, Mr. President. We also have with us in the gallery, Mr. President, Governor Mix Villafuerte of Camarines Sur. He's with us today.
Welcome to the Senate.
May tokayo. Mr. President, with the permission of the body, we move to resume consideration of Senate Bill number 1083. This is an act amending Republic Act 9372, otherwise known as the Act to Secure the State, Protect the People from Terrorism.
Is this the walang kamatayang anti-terrorism act?
Walang kamatayan. Last year pa ito, sir.
All right. Any objection? Hearing none. Consideration is in order.
Mr. President, may we recognize the sponsor, Senator Panfilo M. Lacson, and to interpolate the distinguished Minority Floor Leader, Senator Franklin M. Drilon.
For the nth time, Senator Pampilo Lacson is recognized, Chairman of the Committee on National Defense, to interpolate. Senator, who will interpolate? The Minority Leader, Senator Frank Drilon.
Thank you, Mr. President. As long as Senator Lapid has not interpolated yet, all interpolations are welcome.
Thank you, Mr. President. Thank you, Mr. President, and with the permission of the Chamber and with the consent of Senator Lacson, allow us to take the floor once more.
Thank you to the distinguished Minority Leader. Anything that will improve the final version of this measure, definitely we welcome
Thank
it,
you
Mr.
very
President.
much, Mr. President, but I would just like to place of record that maybe we can finish today, given the comments of the Senate President, at least on my part. but we cannot guarantee that the interpolation will finish because in the list is Senator Gordon. Thank you, Mr. President. Mr. President, our interpolation this afternoon will touch on the definition of terrorism. Mr. President, the acts being punished here must have legal precision because in many of the acts punished, the penalty is life imprisonment. So that therefore, we must be very clear of what acts are being punished. As I said, we must have legal precision and certainty in the definition of terrorism, which we are punishing by life imprisonment. The issue, therefore, is when will one be charged with violation of the Anti-Terror Act? When will he be charged with rebellion? When is it coup d'etat? When is it sedition? And the reason for that is in our statute right now, statute books, there are acts which can qualify under any of these four laws. We take note that terrorism itself, in the definition internationally in many fora, is that the main objective of terrorism is to sow fear and spread violence. But the bill that we are proposing today and we're debating on would include as an element the fact that the purpose of the the Terror Act would be qualified through their purpose, namely to intimidate, put in fear, force or induce the government or any international organization or the public to do or abstain from doing any act or seriously destabilize or destroy the fundamental political, economic, and social structures of our country, or create a public emergency or undermine public safety. We are reading this, Mr. President, because the reality is when a fiscal is confronted with a complaint by the law enforcement authorities, he has to judge what information will be filed in court, especially that the elements of terrorism and, for example, coup d'etat, of rebellion, of sedition, would have similar elements. So the question in general that we have, sir, is how does one distinguish and what kind of case is, how does the fiscal decide which, whether the act is punishable as a rebellion, sedition, coup d'etat, or anti-terrorism? What are the distinguishing factors?
I'm glad that the distinguished gentleman from Iloilo asked that question, Mr. President. And to further clarify, aside from the definition as contained in Section 4 of this proposed measure, further guidance may be taken from existing jurisprudence, Mr. President. I'm referring to GR number 231658, decided by the Supreme Court only on July 4, 2017. This is Lagman versus Medialdia, Mr. President. Now, it says that in determining what crime was committed, we have to look into the main objective of the malefactors. If it is political, such as for the purpose, I'm quoting from the decision, Mr.
Yes,
President. If it is political, such as for the purpose of severing the allegiance of Mindanao to the Philippine government to establish a wilayat therein, the crime is rebellion. If, on the other hand, the primary objective is to sow and create a condition of widespread and extraordinary fear and panic among the populace in order to coerce the government to give in to an unlawful demand, the crime is terrorism. Here, we have already explained and ruled that the President did not err in believing that what is going on in Marawi City is one contemplated under the crime of rebellion, Mr. President.
Yes, thank you, Mr. President, for that citation. But let me read into the record the definition of rebellion under Article 134 of the Revised Penal Code. It says, the crime of rebellion or insurrection is committed by rising publicly and taking arms against the government for the purpose of removing from the allegiance to said government or its laws the territory of the Republic of the Philippines or any part thereof, or any body of land, naval, or other armed forces, or depriving the chief executive or the legislature, wholly or partially, of any of their powers and prerogatives. This is exactly what also the act of terrorism would have as a purpose when it says seriously destabilize or destroy fundamental political, economic, or social structures of the country, and forcing the government to do any, force or induce the government or any international organization or the public to do or to abstain from doing any particular act. We find the definition broad enough to include rebellion, and that is, I guess, where our difficulty is, because the reality is the fiscal would have to judge what crime or what information to file. And we do hope that we can spread into the record the difference, because this is what the fiscal will be looking at. What is the intention of Congress?
That is the reason, Mr. President, that we inserted the phrase under the second paragraph after enumerating the acts that would constitute terrorism, acts of terrorism. We cited in the second paragraph, when the purpose of such act by its nature and context is to intimidate, put in fear, and so forth and so on. Now, let me go further in my citation of the Supreme Court ruling on Lagman versus Medialdia. No? Besides, this is another citation. Besides, there is nothing in Article 134 of the RPC or the Revised Penal Code and RA 9372, Human Security Act, which states that rebellion and terrorism are mutually exclusive of each other, or that they cannot coexist together. They cannot coexist together. RA 9372 does not expressly or impliedly repeal Article 134 of the Revised Penal Code. And while rebellion is one of the predicate crimes of terrorism, one cannot absorb the other as they have different elements, Mr. President. That is quoting again from the Lagman versus Medialdia.
Okay, at least we...
And to further, Mr. President, under the Revised Penal Code, the elements of rebellion are as follows: that there be a public uprising, and B, by taking arms against the government.
Yes.
Okay. 2, that the purpose of the uprising or movement is either A, to remove from the allegiance to said government or its laws, sa paragraph 1, the territory of the Philippines or any part thereof, or 2, any body or of land, naval, or other armed forces, or under subparagraph B, to deprive the chief executive or Congress, wholly or partially, of any of their powers, prerogatives, Mr. President.
Thank you, Mr. President. In our view, those elements of rebellion would be encompassed in the general purpose, which would qualify an act as an act of terrorism. And what is that? An act of terrorism is done for the purpose of forcing or inducing the government or any international organization or the public to do or to abstain from doing any act. I think the definition is broad enough to certainly cover rebellion. And we're raising this only for the guidance of those who will implement this law, Mr. President.
Thank you, Mr. President. In our definition, there is no public uprising involved in the crime of terrorism, as in the case of rebellion, Mr. President. There is no public uprising. There is an element present in the crime of rebellion that is not present in the crime as proposed under this bill, Mr. President.
There is no public uprising.
That is correct, Mr. President. So, meron pong delineation.
Yes.
Kung wala naman pong public uprising,
But, okay.
hindi
But,
po masasaklaw ng terrorism.
now, an act of violence would have to be something that cannot be, will not qualify as rising publicly.
Those are two different elements, Mr. President. In my view, at least, Mr. President. Kasi malinaw naman doon sa rebellion under Article 134, yung public uprising.
Right.
In the case of this proposed measure, hindi po kailangan yung element ng public uprising.
The Marawi siege, Mr. President, is that rebellion or is that an act of terrorism, assuming that we have this law? When
Kindly state the
terror-
question again, Mr.
Sorry?
President. Kindly state.
The Marawi siege, if it happened after we passed this law, and you are the prosecutor, Mr. President, which crime will you charge those who staged the Marawi siege? Is it rising publicly and therefore rebellion, or is it an act of violence which would be under terrorism?
It will depend on the evidence as presented by the prosecutor, Mr. President. If the prosecutor would go to the direction of filing, assuming that we have passed this,
Yes,
this
yes,
measure,
yes.
kung ang elements magpo-fall under the provisions of the proposed measure, then the prosecutor may file for violation of anti-terrorism law. But if the nature and context by which the crime was committed would not constitute violation of this act, then, and as in the case of the Marawi siege, the case that was filed was rebellion, Mr.
No,
President.
yes, sir. But in fact, the act in what took place in the Marawi siege could very well fall under the definition of the purpose for which terrorism is committed, and that is to force or induce the government or the public to do or abstain from doing any act, and seriously destabilize or destroy the fundamental political, economic, and social structure of the country. When they try to remove Marawi from the country, that would be rebellion, or that would be...
You are correct, Mr. President. No, I will not argue the point.
Yes.
However, the law that was existing or is still existing when the Marawi siege was committed, merong predicate crimes. That's why
Yes.
government agents chose to file the case of rebellion.
Yes.
Because they will have to prove first the crime of rebellion being committed before they can proceed
I
to...
guess our question, sir, if I may interrupt, we are assuming a situation where the Marawi incident took place when we have already passed this law.
Then I suppose that the government would have filed a case of terrorism instead of rebellion. Because if we agree to remove or delete the predicate crimes, then it would be convenient, not convenient, but maybe it would encourage government to file the case of terrorism instead of rebellion.
All right.
I think that's the primary reason why government chose to file the case of rebellion against the attackers in Marawi instead of terrorism.
Yes.
Aside from the 500,000 peso
Yes.
penalty or fine,
Which we're deleting.
which we are deleting, Mr. President.
Now,
And by the way, Mr. President, in the case of terrorism, maski isang individual pwede mag-commit. But ang rebellion, there must be public uprising. So it necessitates the participation of other individuals, Mr. President, not just one person. Because I cannot imagine one person or individual committing public uprising.
all right. If I were the defense counsel and my client is being charged with anti-terrorism
Under this proposed measure.
under this proposal, we know that the crime of rebellion does not carry the penalty of life imprisonment. Does it? Just to check.
I think it is also a capital offense, Mr. President. That is also a capital
Rebellion?
offense, Mr. President. I may be wrong, Mr. President.
Yes,
Stand corrected.
I don't know, that's why I'm also asking. But assuming, for the sake of argument,
That it is not a capital
that
offense.
rebellion is not a capital offense, we can check that. If I were the defense counsel, I will try to prove that the act committed was rebellion and not terrorism. Question, assuming that I'm able to prove rebellion, but the charge is terrorism, can I be convicted for rebellion?
Yes, sir. Because that's another offense.
Yes, sir, but the
I
offense
don't
of...
think double jeopardy, the second jeopardy will set in, Mr. President.
Yes, sir.
Because even if the crime of terrorism under this measure is dismissed for some reason, the crime of rebellion can still be pursued.
Yes, the question is, I have no question in my mind that the crime of rebellion can still be pursued because there is no double jeopardy.
That is
But
correct, Mr. President.
can the judge, having heard the evidence and having seen that the element of terrorism has not been proven, but in fact all the evidence point to rebellion, can the judge convict the accused of rebellion in a charge sheet or information which charges terrorism? Let me premise this, Mr. President, as we lawyers know. In the revised penal code, where you are charged with murder and you cannot prove an element, let's say, of treachery, you can still be convicted of homicide.
Homicide.
Because they fall within the same class of crimes or whatever. Now, would that same element or theory be applicable here? Because here, rebellion is punished under the revised penal code and terrorism is punished under a special law. Can you convict one for terrorism or for rebellion under the revised penal code when in fact you are charging him under rebellion, which under terrorism, which is a special law?
As you clearly stated, Mr. President, this is a special law.
Yes.
In the case of murder, downgraded to homicide, iba po yung rule. Yes, the judge cannot convict him for another crime, which is rebellion, if he deems it wise or he doesn't find sufficient evidence to convict the person or the suspect or the respondent under the crime of terrorism, because he had been arraigned for the crime of terrorism, not rebellion, Mr. President. So hindi pwedeng makonvict sa rebellion kasi ang arraignment niya, terrorism.
Well, anyway, just to end the debate there, in the example I gave under the revised penal code, so long as the crimes fall within the same title, you can be convicted of a lesser crime. But I will not tarry any further there, Mr. President. I just request the good sponsor to study this very well.
Yes,
and
Mr.
find out how we can provide in the law elements which can distinguish one from the other, so that the prosecutor will not be in a quandary and the judge will not be in a quandary. As I said, when the committee amendments are proposed, I do hope that the good sponsor can take this interpolation into account.
Of course, Mr. President, except that this is a substitute bill, so I'd leave it to the distinguished gentleman to introduce the amendments.
So, well, maybe we can waive the rules so that we can have a better understanding of this. The other question, Mr. President.
Mapapagalitan tayo ng majority leader, Mr. President.
Ako bahala dyan. No. Oh, the other question, Mr. President, is what is the difference in the elements of a coup d'etat and an act of terrorism? For the record,
Ang coup dito po, under 134A, ang purpose niya, seize or diminish state power. As amended by RA 6968.
isn't it that the purpose of a coup d'etat is to seize or
Yun nga po.
diminish state power? That would also fall under the broad definition of terrorism.
But babalik ulit tayo doon sa intent and purpose. Yung objective ng malefactors, Mr. President, will be guided or will be bound by the definition as to the intent and purpose of the act being committed, Mr.
Because the
President.
way the definition is now crafted, whether or not you're a public officer or a military or a police, you can be convicted under the measure, under the anti-terror measure. Whereas a coup d'etat, unless you're a public officer, you cannot fall under this.
Yun na nga po, Mr. President, elements of coup d'etat, and may I enumerate,
Yes.
especially number 1, that the offender is a person or persons belonging to the military or
That's
police,
correct, yes.
or holding any public
Yes.
office of employment,
Yes.
Mr.
My
President.
problem, Mr. President, is that your definition of terrorism
Any person,
covers any person.
yeah.
And that is why I bring back our debate the last time. You were saying, but it was not clear. And I will cite Senator Hunasan only by way of example. Because he's classic. Now, if he is still a member of the armed forces, and he commits what he committed, will he be charged as a terrorist or a coup d'etat? I'm not saying that there is proof against Senator Hunasan, just on a theoretical and discussion. If Senator Hunasan was still a colonel and he committed what he did commit, and we have already the anti-terror law, with what crime will he be charged?
Ako dito, Mr. President, kasi klaro naman yung kanyang purpose eh. Ang purpose ni Senator Honasan, assuming that he's guilty, no? Of course, he's guilty. The purpose of the attacks is to
Kaklase mo
seize,
po yan, hindi...
stricken off the record, Mr. President, seize or diminish state power.
Yeah, the purpose is to diminish state power, which is also covered by the broad definition of forcing or inducing the government
Yes.
to
I see your point, Mr. President, but the evidence will clearly show the objective or the intent or purpose of the person committing the act, Mr. President.
Mr. President, wouldn't this position of the person be more crucial? Meaning, if he committed the acts of terrorism while he was a public officer, he would be charged under coup d'etat under Article 134A rather than an act of rather than a terrorist.
To seize or diminish the state power, magkaiba naman po yun doon sa you're preventing government to perform its function, Mr. President. We'll
Kaya-
always be guided by
Yeah,
the
that is
intent
why
and
I
purpose.
thought, Mr. President, that the clearer guide would be whether or not, just whether
Yes,
or not.
I understand where you're
Yeah,
coming from,
is-
Mr.
is,
President.
whether or not the person being charged is a public officer or a military or police officer, which therefore qualifies it under coup d'etat. But if he's not a public officer, then it can be under the act of terrorism. But my problem is, in your definition, terrorism covers any person. And that is why I asked this question, because I remember that the first time I took the floor on the period of interpellation, you clearly stated that Senator Honasan, under these circumstances, cannot be charged under terrorism because he is a public officer and therefore he commits a coup d'etat. On the other hand, in the second section, on the same period of interpellation, you said that Senator Honasan can be charged for
Coup d'etat.
no,
Terrorism?
terrorism. Which is which now, Mr. President?
I wish Senator Honasan were here, Mr.
So
President.
that he can
So
define.
he can interject and,
Anyway, again,
and state,
yeah, that's
and
for
state
the
for the
record.
record his purpose at the time, Mr. President.
Well, my problem with that is the purpose could be the same, whether it's an act of terrorism or a coup d'etat.
I think the operative phrase is seize or diminish state power, Mr. President. I think it was clear when Senator Honasan reportedly embarked on several adventures, as a matter of fact, was to seize power or diminish state power. Hindi naman po ang purpose niya was to terrorize eh.
No.
Klaro
But
po yun.
well, that's precisely my problem. Hindi naman ang purpose niya only to terrorize. But the purpose is to seize and diminish state power and also to destabilize political structure. Anyway, as I said, I would like to see this clear definition of or clarity in this area, because I see this I see this as an area of confusion and difficulty. Of course, that is our view. The sponsor may take another view, but I think there is nothing wrong with clarifying so that the
Of course,
intent of
I am
the
in full
chairman-
agreement, Mr. President. That's why this discussion might, establish the proper language in defining the acts of terrorism as it appears in the proposed measure, Mr. President.
So, again, I would, just to summarize, we would earnestly request the good sponsor that in the period of amendment, the good sponsor will now make it clearer in the language, which is what are the elements of terrorism, of rebellion, of sedition, or coup d'etat, which would distinguish one from the other, so that the prosecutor and the judge can see clearly which direction they should take in punishing the acts being committed.
With your active help and support, Mr. President, I think we can come up with a...
I understand. I can
I understand where
sympathize.
you're coming from
I-
because
I can-
medyo
and I-
encompassing yung mga elements dito as proposed, Mr. President.
And I can sympathize with the sponsor. It's not easy.
Thank you for sympathizing with me, Mr. President.
That is why my luck, however, is that I am the one asking the questions.
We're dealing here with at least 109 definitions of
Yes,
terrorism.
yes.
That's why you really have to clarify each and every word
Yes.
that is used in defining only in the definition of terrorism, Mr. President.
Yes. Now, again, the general question. When is a liberation or democracy movement an act of terrorism, if it is? In other words, how does one distinguish between a liberation movement, a democracy movement from terrorism? For example, Nelson Mandela. Was Nelson Mandela a terrorist, or Nelson Mandela was the leader of a liberation movement? Assuming we have a Nelson Mandela in the country at some future time, would that person be would he be considered as the leader of the liberation movement or a democratic movement? Because, Mr. President, this is not a theory. It actually happens as we talk.
Even in the Philippines, Mr. President.
I'm sorry?
Even in the Philippines in 1986.
Yes, it actually happens.
Yes.
Now, in 1986, it happened in Hong Kong. You know, there are democracy movements. The violence takes place. If that happens here, is he a terrorist or a leader of a democracy movement?
Mr. President, I was handed this quote, ano? One man's terrorist is another man's freedom fighter.
That's correct. So where does that leave
And
us?
as articulated by Senator Tiveros, I think, if I recall it correctly, yung intent, halimbawa, legitimate, well, quote-unquote, legitimate yung purpose in expressing dissent, say, under the condition of a martial rule, where marami ng mga abuses. I'm not trying to put on the spot. Wala naman pala dito. Ayun. And, Mr. President, and, people would rise even up in arms, to correct an abusive regime. And nanalo sila. Then, yun nga yung quote na, one man's terrorist is another man's...
Kung hindi po sila nanalo,
patay sila, Mr. President. Terrorist sila. Or mga rebel sila. And they will be answerable criminally for their acts. And that's a fact of life, Mr. President. As in the case of Nelson Mandela, the reason why he's now being acclaimed as a hero, dahil nanalo sila, Mr. President. That's a fact of life. But going back to our discussion, I'd like to believe that we have to really consider and look seriously at the intent and purpose of the act.
yeah.
Kaya nga dinagdag pa natin
I
yung
do
by
not-
its nature and context, Mr. President.
Yes, I do not disagree with that generally, except that it's not, if you analyze it deeper, the broad definition of terrorism would include rebellion, would include sedition, would include coup d'etat. In any case, we have already manifested that
At the proper
maybe at the appropriate time, maybe the good sponsor can look at the definition more closely and see how this vagueness or broad definition can be better addressed. So absent the purpose or the intent that would qualify it as a act of terrorism, it would be punished under the revised penal code.
That is correct, Mr. President.
Rebellion.
Or coup d'etat. Yeah.
Senator Gordon already wants to participate in the debate. All right. One more issue, and then I'll yield the floor to Senator Gordon. And this is the issue of proscription.
Yeah.
Now,
prescription. Tama. Yeah.
Mr. President, under the proposed measure, it is a mandatory requirement for the judge to issue a preliminary order of prescription within 72 hours after the filing of the application, should the judge determine that there is probable cause to show that a group is a terrorist organization.
That is correct,
sir?
Mr. President.
And this preliminary order, based on probable cause under the measure, can be the basis for the detention of the alleged members of the organization.
As listed, Mr. President, each and every member, kailangan meron din makitang probable cause ng membership of a proscribed, even in the preliminary order prescription organization, Mr. President.
We're just talking first about the order of prescription.
Okay.
And based on probable cause, a preliminary order can be the basis of detention of the alleged members of the organization. Is that a correct reading, Mr. President?
That is correct, Mr. President.
Now,
Even the freezing of the assets.
now, and then the burden of proof is shifted from the government to the proscribed group because it imposes upon the group the burden of showing for good cause why a preliminary order of prescription must be set aside. In other words, the one who is charged will be the one to show that the order has no basis. Isn't that a little difficult in terms of our Constitution? Because the burden of proof is shifted to the defendant. The law creates a presumption that it is a proscribed organization, and therefore, you must now prove that it is not. It's a little, to my mind, contrary to what we understand to be the presumption of innocence when we have that kind of a system. The concern is that the preliminary order of prescription may be used to justify the detention, random detention of individuals under the guise of their membership in a preliminary prescribed group. In other words, once the judge has ruled a probable, or on the basis of the preliminary submission, that XYZ organization is a terrorist group, then on that basis of the order of prescription, the detention may be had, and the applicant has to show that the order has no basis because the burden of proof is shifted to him, rather than what we ordinarily rather than the burden being in the prosecutor and in the government. Don't we find this a little
Mr.
difficult?
President, it is akin to a respondent against whom a warrant of arrest was issued by the judge on the basis of probable cause.
Yes.
Remember, he has not been convicted yet. And while undergoing trial, since the crime is unbailable, then he is detained until such time that the judge grants bail or the judge determines or the prosecution fails to prove guilt beyond reasonable doubt. Pareho rin po yung principle na yun. So it doesn't necessarily mean na yung burden of proof has shifted to the respondent, Mr. President, to prove that he should not be detained. Because remember, the the threshold that the judge would follow before he will issue a preliminary order prescription is probable cause. In the same manner that when a prosecutor files the information, clearly the prosecutor has already found probable cause against the individual. And the judge necessarily, after judicial determination of probable cause, would issue a warrant of arrest. Pareho rin po yun, wala pong pagkakaiba doon sa regular due process that we are following or observing, Mr. President. In this case, tama po yun. Detained yung person because the judge himself has already found probable cause to proscribe the organization to include the members who have been established to be members of that proscribed or preliminarily proscribed organization. And within 6 months, the judge will have to determine if yung preliminary order prescription will be a permanent order, Mr. President. So I don't see any deviation from the regular practice of detaining a person after finding probable cause. Of course, under the new rules, hindi porket may probable cause yung prosecutor, yung judge will automatically follow. There is such a thing as judicial determination of probable cause, which I believe is also similar in this situation, Mr. President.
Yeah, yes, the present procedure is that when the information is filed, the judge, on the basis of his own examination,
Yes, Mr. President.
personal examination, would determine that
There is
a
indeed-
warrant of arrest
Or
should
there's
be issued.
indeed probable cause.
Huh?
There's indeed, we call it judicial determination of probable cause.
That's correct.
Before, during our time, when I was still in, with law enforcement, hindi na kailangan, pag sinabi ng prosecutor na we're filing this information on the basis of probable cause,
yes.
the judge had no other...
That's correct. That's how the jurisprudence, that's how the jurisprudence developed.
Evolved,
So
yes.
so that at a certain point, the Supreme Court has ruled that the judge would have to examine personally and determine whether or not
There's
there
probable
is
cause.
probable cause. Is that procedure applicable here?
Yes, Mr. President.
So that when the application is filed for declaring an organization as a proscribed organization, the judge would have to determine.
Yes, Mr. President.
Now, maybe we can include, in other words, the provision in the Constitution will apply
Yes,
insofar
Mr.
as that's
President.
concerned.
Without the judge finding probable cause, he would not issue a preliminary order of prescription.
Okay, can we take note of that? Now, what
Ito po
about,
yung process, if I may, Mr. President. As provided for, under the proposal, with the authority of the Anti-Terrorism Council, upon the recommendation of the NICA, the DOJ shall file an application before a competent RTC for the prescription of any group.
yes,
Tapos, pwede rin gumawa ng preliminary order prescription. But, kailangan sundin pa rin ng judge yung judicial determination of probable cause before he issues the preliminary order prescription. Yung pa rin po ang threshold.
okay. I will eagerly await how that would be phrased in the amendments that I assume will be submitted so that that kind of situation will be clearly enunciated in the law. Now, what about, okay, the judge determines that that there is probable cause to declare an organization as a proscribed organization and issues the order. Fine. What about the individual who are supposed to be members of that? What kind of safeguards can we include in the law so that the mere fact that it is a proscribed organization should not result in every member, alleged member,
indiscriminate.
be arrested. But remember that under the proposed measure, Mr. President, you can be detained for 14 working days. So there could be some degree of arbitrariness. If, for example, I am alleged to be a member of a proscribed organization, and therefore I am arrested and detained for 14 days, working days, on the allegation that I'm a member of an organization which is proscribed. How do we guard against abuses?
That is a different matter, Mr. President. To arrest an alleged member of a proscribed organization, it is incumbent upon the government to prove that he is really a member before he can be arrested. Yun naman pong warrantless arrest, iba naman po yun.
No, I'm not
Hindi
talking
dahil
about-
sa merong reasonable ground or merong ground yung police officer to arrest a person just because he is reportedly a member or allegedly a member, hindi po pwedeng basta arrestuhin. Government should prove that he or the person to be arrested is indeed a member of that proscribed organization, Mr.
Not
President.
only he's a member, but he knowingly,
Yes.
under the measure, knowingly became a member.
That is correct, Mr. President.
So that unless there is proof that he knowingly became a member, knowing that it is a terrorist organization, he cannot be arrested.
Yes, Mr. President.
Yeah, we make it clear because that is very critical as a for the appreciation of the measure. Senator Gordon wishes to intervene. I have no problem with Mr. Gordon.
Ito po yung sa Section 9, with the indulgence of Senator Gordon, no, yung second paragraph, any person who shall voluntarily and knowingly
Yes.
join any organization, association, or group of persons knowing that such organization, association, or group of persons is proscribed under Section 24 of this Act, or the United Nations Security Council designated terrorist organization, or organized for the purpose of engaging in terrorist acts shall suffer the penalty of
So just for the record, it is not mere membership in the proscribed organization, but it must be shown that he knowingly and voluntarily, with full knowledge of the nature of organization, he joined it. In other words, it is not automatic
Yes, sir.
that one who is a member of a proscribed organization could be arrested.
Yes,
on
sir,
the
that
basis-
is correct.
Yeah.
That's
Is that correct?
expressly provided in, under Section 9.
Thank you, Mr. President.
Yes, Senator Gordon, I yield the
Gentleman
floor.
from Iloilo read my mind.
Okay.
This time, it was a correct reading of my mind, Mr. President. That mere membership is not a ground for
Arrest.
Arrested.
He has to knowingly
Yes.
join the organization.
And it must be proven before the court that he is a member who knowingly joined that organization.
Very important for the Supreme Court later on when they interpret. Thank you, Mr. President.
As a matter of fact, Mr. President, there's a pending petition from DOJ to declare CPP-NPA as a terrorist organization, proscribed terrorist organization. And the government has submitted a list of members. So doon lang po nakalimit yung mga pwedeng arestuhin. And later on, if they submit, say, ano yun, supplemental? They can submit or file supplemental petition to include additional members. Kailangan i-prove pa rin nila na yun nga, knowingly, voluntarily, and so forth and so on.
But isn't there a phrase somewhere in the proposed measure is presumed to know? You are qualified for arrest if you are presumed to know.
Let me check, but as far as I'm concerned, wala po yung presumption
Mayroon po eh.
of knowing.
Yeah? It is in providing material support.
In providing material
Yes,
support.
yes. Meron po. I yield the floor to Senator Tolentino, Mr. President.
Just with the permission of the gentleman, just one
Senator Tolentino.
clarificatory question, Mr. President. The United Nations declared proscribed organizations, will this need a court determination or validation whether these are really terrorist fronts or organizations, or we just rely on the declaration of the United Nations, Mr. President?
I suppose it should require an act of a court in the Philippines, no, to formalize the United Nations resolution declaring a terrorist organization as a proscribed organization, Mr. President.
Mr. President, may we know from the good sponsor that at this stage, preliminarily, do we have a listing of the said United Nations proscribed organizations? Will this include the well-known Middle Eastern terrorist fronts that this representation mentioned during the interpellation granted by the good sponsor?
You're
Mr.
referring to
President?
the UN list?
Yes, Mr. President.
There is a list, Mr. President. Al-Qaeda is one. ISIS is another, Mr. President. There's a list under the United Nations resolution of this proscribed terrorist organization.
So, Mr. President, from the answer of the good sponsor, it would now mean that even if there is a list coming from, a prior list coming from the United Nations, it is not automatic, Mr. President, that knowingly becoming a member of the proscribed organizations by the United Nations would merit an offense as enunciated by the proposed law, Mr. President.
Should be formalized by a competent regional trial court, Mr. President,
Again,
to
Mr.
formally proscribe the... Yes, it must be brought before a court who will now formally issue an order of proscription, Mr. President.
That's my final query again, to reiterate my previous interpellation, and which I think was already answered. If the court determination would come out during that hearing, how would the accused, the member, exculpate himself? Because the declaration probably might come out during the hearing, and the timing of his membership might be a priori, or probably it was done before the declaration of the court that said organization is a terrorist organization. Just last one point, Mr. President.
Hindi ko na po nasundan sa haba ng tanong ninyo.
Ay, po, to rephrase, Mr. President, maaari po ba kaya doon lang sa hearing ay nalaman nung naging miyembro na yung palang nasalihan niya ay isang terrorist front? So how can he now
Hindi po papasok sa knowingly.
Hindi na.
But of course, kung kaya na ma-approve ng gobyerno na knowingly, then problema niya yon, Mr. President. Matter of evidence eh.
Oh.
Yes.
I thank the good gentleman and the minority
Thank you.
leader for the time
Mr.
given. I yield the
President,
floor.
may I suggest that on page 24, which
Section, Mr. President.
section 22, which includes a new section 25, that the good sponsor examine closely the paragraph starting on line 22, which says, the court will schedule a summary hearing at a date and time within a 6-month period from the filing of the verified application, when the respondent may, for good cause, show that the order of prescription should be set aside. This is where I was saying that we have shifted the burden of proof to the one who is arrested, because he has now to show that the order of prescription should be set aside, rather than the government justifying why it should be maintained. So something would really, that's something that would not be acceptable as a principle of fair play and justice.
Ganito po yan, Mr. President. Yung burden of proof stays with the government. Ano? But after 72 hours and the judge determines probable cause for the issuance of preliminary order of proscription against the organization concerned, what is shifted is the burden of evidence, which is shifted from the government to the other party.
Mr. President, the burden on the government is only to show probable cause.
Within a 6-month period, Mr.
Yes,
President.
and therefore, that standard of proof is not that high, but then but then under the proposal, you already shift the burden to the accused. Isn't it better if the order is reversed so that within that period, the prosecution must show that indeed the preliminary order is valid and supported by evidence, rather than shifting the burden to the defendant? Because remember, Mr. President, that this is a summary hearing, and this is just for the establishment of a probable cause. The standard of evidence is low, or the hurdle for purposes of the evidence is low, but yet the burden is shifted to the accused, Mr. President. We would like to see a revision of this proposal, of this provision, so that it will be consistent with fair play, Mr. President.
Yeah, I agree, Mr. President. I would like to cite here another jurisprudence, Corpus versus Sarmiento, GR number 45137. It says here, when a prima facie case is established by the prosecution in a criminal case, as in the case at bar, the burden of proof does not shift to the defense. It remains throughout the trial with the party upon whom it is imposed, the prosecution.
Yes.
It is the burden of evidence which shifts from party to party, depending upon the exigencies of the case in the course of the trial. This burden of going forward with the evidence is met by evidence which balances maybe as introduced by the prosecution. Then the burden shifts back, Mr. President. I'm open to amendment or open to further improving the language under paragraph 2, under section 25. No?
Thank you, Mr. President.
Pero nakalagay din naman dito na when the respondent may for good cause show why the order of proscription should be set aside. No? So, nandun po naman yung provision na yun. But anyway, as I've stated earlier, I'm open to further improving this particular
Thank you, Mr. President.
provision. Hindi naman. Payag naman. Ikaw naman. Ni-intriga mo ba yata?
Ano daw?
Sabi niya, in other words, ayaw ko raw pumayag. Sabi ko, hindi naman. Ni-intriga mo lang kami.
This is undue interference, Mr. President. On page 25, Mr. President, who is the deputized law enforcement agency or military personnel? My impression is that only certain officials are authorized to file the charges, and who is the deputized law enforcement agency or military personnel? May we be merited with an explanation on this, sir?
It's rather vague, Mr. President, but I would like to believe that it is the ATC that will issue the authority, the Anti-Terrorism Council. But you are correct,
So,
Mr. President, we should be more specific.
All right. So conceptually, it is the Anti-Terrorism Council, which is the source of
Deputization.
deputization.
Yes, Mr. President.
Now, the good sponsor on page 20 specified 14 working days. This is actually 3 weeks if you consider it on a calendar basis. Because if you exclude
Five,
Saturday
and
and
four.
Sunday, this is actually 3 weeks, sir.
Yeah, 5, 5, and 4.
Yes.
No, working days, yes. 5, 5, which
That's
is,
19
should
days.
be equivalent
Huh?
to 7. Another 5, which should be equivalent to 7. And
Yes.
another 4.
Yes.
Yes, Mr. President.
Yes. Is it possible that we just, because 14 working days can be subject to various interpretations. It may happen that there are special non-working holidays, there are working holidays, et cetera, et cetera, et cetera.
Holy Week, Mr.
Huh?
President, Holy Week.
Holy Week, you know. Would the bill be vigorously altered, violently altered, if we talk about calendar days? So that there is no more determination as to what, there's no more debate as to whether it is a working day or a non-working day.
We can make a bargain, we strike a bargain, Mr. President.
Yes.
14 calendar days, subject to an extended period of, say, another 4 days, or maybe 5 days.
Who determines that, sir?
The court, Mr. President.
Okay, yeah, we're willing to consider.
Because in other jurisdictions, Mr. President, meron silang extension eh.
Okay.
Singapore, as I mentioned earlier, 732 days. Tapos pwede extend indefinitely.
Yes.
No. In other jurisdictions, merong ganon. So
Yes.
we
We're
can.
open to that, sir, as long as it is reasonable.
Yes, Mr. President.
So we will await the proposed amendment. Also on page 20, lines 11 to 14, the provision is proposed to be deleted. The provision existing would provide that the arrest of those suspected of the crime of terrorism or conspiracy to commit terrorism must result from the surveillance under Section 7 or examination of bank deposits under Section 27 of this act.
We're
Why
on what
is-
section, Mr. President?
This is on page 26, I'm sorry,
26.
page 26, lines 11 to 14, which is a provision of the existing law, but which is now bracketed, and therefore proposed to be deleted. May we spread into the record the rationale for this deletion?
Provided that the arrest of those suspected of the crime of terrorism must result from the surveillance under Section 7. One minute suspension, Mr. President.
Session suspended.
Pabor na ito eh. Pabor na ito sa safeguards eh, di ba? Dahil result lang ng surveillance eh. Kaya dinilit na natin eh. Move to resume, Mr. President. Actually, pandagdag sa safeguards to, Mr. President. If
Sorry?
you additional
Session
safeguard, because under the under 9372, if we will read the proviso or the provision that that we propose to delete, provided that the arrest of those suspected of the crime of terrorism or conspiracy to commit terrorism must result from the surveillance under Section
Yes,
7
Yes.
and examination of bank deposits
Yes.
under Section
That is
27.
proposed to be deleted.
Yes, Mr.
Yeah,
President.
our question is, can the good sponsor spread into the record the rationale for this deletion, sir? Why is it being?
Additional safeguard, Mr. President.
In fact, this is a safeguard, and it is proposed to be deleted, sir. So we just want to, the record to reflect the rationale for the deletion of the safeguard.
In lieu of that, one minute suspension, Mr. President.
Yes, sir.
Session suspended.
Section 7 is... surveillance ng... So, ano reason for deletion? And in lieu of the deletion, ito yung nilagay natin. Inalis na natin yung result from surveillance. Ang nilagyan na natin, to further determine. In lieu of that, ito yung nasa bold. To prevent. Ready to resume, Mr. President. This is proposed to be deleted para maging proactive, Mr. President, yung ating, because as stated in the previous paragraphs, no, what we're aiming here is to prevent the occurrence of acts of terrorism, because the damage is so huge, loss of lives and properties. So in lieu of that, we inserted the phrase under Section 27, Mr. President. Personnel or deputized law enforcement or military, if it is established that one, further detention of the person or persons is necessary to preserve evidence related to the terrorist act or complete the investigation. 2, further detention of the person or persons is necessary to prevent the commission of another terrorist act. And 3, the investigation is being conducted properly and without delay, Mr. President.
Okay. Anyway, again, this is one area probably which the good sponsor, if he are minded to, if he is minded to, can clarify in the
Yes,
amendment.
Mr. President.
And just for the record,
Anyway, may additional safeguards naman dito eh. This can be balanced by the inclusion of several additional safeguards under the proposed measure, Mr. President. It says the law enforcer taking custody shall notify in writing the judge nearest the place of arrest of the following facts: no? Time, date, and manner of arrest, location or locations of the detained suspects, physical and mental condition. And then also, fairness din yung ATC, the Anti-Terrorism Council. And we agreed earlier to the proposal of Senator Ontiveros to include the Commission on Human Rights.
Now, in the previous answer of the good sponsor, he says that he is amenable to 14 calendar days, provided that an application for an extension can be provided,
That is correct, Mr. President.
3 or number of days now. That should be before the court,
Before the court.
not just the Anti-Terrorism Council.
No, Mr.
In
President.
other words, it must be a judicial process
It should be by the court, Mr.
by the
President.
court. Yeah, okay. Again, just for the record, why is the requirement for an official custodial logbook under Section 23 of the present law being deleted, Mr. President?
In lieu of that, Mr. President, those that I've enumerated earlier, yun ang pinalit natin, yung the judge nearest the place of arrest must be informed.
Okay.
So mas effective pa yun, Mr. President, than the
Okay.
custodial logbook.
One minute suspension, Mr. President.
Session suspended.
Ano meron pa? Ha? Ano? Mhm. Ready to resume, Mr. President. Just a few more minutes
Session resumed.
with the indulgence of the good sponsor before I yield the floor to Senator Gordon.
Is that a threat, Mr. President?
On page 34, we are deleting section 27 and section 28 on the judicial authorization to examine bank deposits, etc. Does this mean that the bank deposits can be examined even without court authorization? Or is that covered by other sections?
That's a resentment of terrorist financing under 10168, Mr. President. Yung terrorist financing,
Yes, okay.
yung effectively amending yung Money Laundering Act, Mr.
Meron,
President.
ha? Okay. Mhm. Meron, no?
Ang tinanggal po is yung penalty.
Kasi nga, naging superfluous na. Surplusage. Tawag nyo doon. Ang tawag nyo doon, surplusage. Yan. Legal term ba ng mga lawyers yung surplusage? Yan. Yung sa language nyo nga, Mr. President, surplusage. Already
Surplusage,
provided
yes. Yes,
by
yes.
other laws.
Yes. Okay, on page 40,
Yeah.
on section 32, which is on bank inquiry and examination. Does the law enforcer need authority from the court to examine bank accounts in case the court declares an organization as a terrorist organization? In other words, would the mere designation as a terrorist organization authorize the law enforcement to examine and open bank accounts?
The provision under 10168 is applicable here, Mr. President.
Sorry, sir?
The RA 10168, yung terrorist financing, applicable din po dito.
And for my education, for the education
Judicial.
of this representation, what are those, Mr. President? Because the way I read this, Section 32 as amended, it says, upon order of the court declaring an organization, association, or group of persons as terrorists or an outlawed organization or association in accordance with Section 24, law enforcement agents may, law enforcement officers or military personnel through the AMLC or Anti-Money Laundering Council may conduct an inquiry and examine the bank accounts of and investments of such organization, group of persons or individual. In other words, the situation here is upon the being declared as a terrorist organization, without any further need of a court authorization, the bank accounts may be opened. Through the Anti-Money Laundering Council.
Yeah, under Section
32,
11, Mr. President, of the Anti-Money Laundering Act, Mr. President, ATC is hereby authorized to issue an ex parte order to freeze without delay. Andun po yun. So, we're just, this is in, with reference to the Anti-Money Laundering Act, Mr.
So
President.
there is an act of the court.
Yes, Mr.
Please.
President.
Huh? No, but would that requirement be dispensed with the way Section 32 is proposed to be amended? Because it is now only, because the way I envision Section 32, if you declare an organization as a proscribed organization, the law enforcement through the Anti-Money Laundering Council may conduct an inquiry and examine the bank accounts and investments of such organization. And then,
Still in effect, di ba?
when then it says, such inquiry and examination shall be in accordance with Republic Act 9160. The problem here, Mr. President, that I see is while one sentence says or implies that it can be done without any court order, the second sentence says the inquiry shall be in accordance with Republic Act 9160, which requires a court order. Can the good sponsor clarify us?
We're not amending the provision under the Anti-Money Laundering Act as amended by 10168 in terrorist financing. Wala po tayong ginagalaw doon.
I know, but what does that mean, sir? Just for the record, for the education of this representation, once an organization is declared as an outlawed organization in accordance with Section 24, and an order of prescription is issued, that would be authority enough for the AMLC to open the accounts of the terrorist organization.
That is correct, Mr. President. As provided under or Section 11 of the Terrorist Financing Act, Mr. President, 10168.
So yung pong nire-refer niyo ng 10168, the court orders only required to freeze, but to inquire.
No,
Ito po yung
isn't the
provision.
court order in those instances refers...
No more, Mr. President.
Huh?
No more. It says here, authority to freeze. The AMLC, either upon its own initiative.
Yes.
I'm quoting from 10168, Mr. President, Section 11.
Yeah, but that's the authority to freeze, sir.
That is correct, Mr.
But
President.
what about the authority to examine?
That's under Section 10, Mr. President. Ito, ano naman? Authority to investigate financing of terrorism. This is under Section 10. The AMLC, either upon its own initiative or at the request of the ATC, is hereby authorized to investigate, et cetera, Mr. President.
Okay. Well, I guess I have exhausted a good portion of our issues. May we just be permitted to raise additional clarificatory questions once the amendments are introduced in accordance with our interpellation this afternoon and the
Certainly.
previous
Certainly,
session.
Mr. President. My mindset and attitude has not changed. Anything that will improve the final version of this measure
Yes.
is most welcome, Mr. President.
That's good, Mr. President, because indeed, we have a common purpose here to strengthen our ability to fight terrorism, but at the same time, we are conscious of our obligation to make sure that abuses are not committed in the name of fighting terrorism, because the the line is very is not very clear, and so therefore we will just await the amendments, and we reserve the right, with the permission of the good sponsor, to raise clarificatory questions when the amendments are introduced.
I'm
With that,
certainly
Mr. President,
with the distinguished minority leader in that regard, Mr. President.
thank you, Mr. President. Para hindi na po sabihin na walang kamatayan, wala na po akong itatanong.
Thank you, Mr. Naku, may hawak na notice.
Naku, yan ang walang kamatayan. Thank you, Mr. President. Thank you, Mr. Good Sponsor.
All right, Senator Gordon, are you going to interpolate?
Yes, Your Honor.
And we have a few minutes of break before you do so.
Okay.
Session suspended. Habol ko. Ito na. Andito yung ano. O yun. Okay, very good. Session is resumed. Before the break, Senator Ping Lacson was still on the floor, still on the Anti-Terrorism Act, 1083, and the Minority Leader terminated his interpellation. I would like to take this opportunity to correct myself in the last session that the Minority Leader did not give me a bamboo tray. He did give me a bamboo tray last December, but I lost it. So he is giving me another one today.
I'd like to also thank you, Mr. President, because apparently he gave me one today, too.
Thank you very much. And, yeah, Senator Pimentel.
The bamboo tree Christmas
Oh,
gift
you?
of the minority leader.
You confirm the
Confirm the
receipt.
Ako, iniimbestiga ko pa sino nag-uwi ng aking bamboo tray. Kaya talagang delikado sila sa akin. It's there? Can I see it? Can you bring it down so I can see it? Have it brought down.
All right.
Thank
So
you,
again, continue interpellations.
Senator Gordon.
Senator Richard Gordon is recognized.
Thank you very much, Mr. President. Just a few questions. I think it's already been clarified. This is really for further clarification in case the matter gets into the Supreme Court sometime in the future. Hopefully, if we clarify this, it will be an easier time for the Supreme Court will have an easier time. Now, in the matter, Mr. President, of proscription, when proscription occurs, Mr. President, just very quick questions. Does that automatically, or at least at the very least, allow the government to start freezing assets?
Yes, Mr. President.
And, Your Honor, under the dangerous drugs law, when assets are frozen after a case, it is immediately forfeited in favor of the government. Now, in this particular case, we are following the AMLA procedure.
That is correct, Mr. President.
We go to AMLA, and then we go to the courts.
The
Or the
AMLA
other way
will
around?
file ex parte to, Mr. President. And the Court of Appeals will issue the freeze order.
Now, my final question, Mr. President, where do the frozen assets go?
AMLA, in the meantime, Mr.
AMLA pa rin.
President. Yes.
So it's under the AMLA law.
It's under the AMLA law.
All right. Just to be clarified, Mr. President. Thank you, Mr. President. That's all. Thank you very much.
Thank you, Mr. President. Mix.
We have just witnessed a miracle.
We should have the doctor check our distinguished senator from Zambales.
I know you all missed my interpellation, so I wanted to disappoint you all this time.
Thank you, Mr. President. With that, no other members wish to interpolate the measure. Mr. President, move to close the period of interpolation of Senate Bill number 1083.
Objection. Hearing none, period of interpellation is closed.
Mr. President, may we recognize the minority floor.
Senator Frank Belon, Minority Leader, is recognized.
Mr. President, we had extensively studied the measure, and it is extremely difficult. There are a lot of implications on every provision, and it involves a study of so many laws. The good sponsor is the one who is most familiar with the bill, as he's the one who drafted it. It is a substitute bill, and under our rules, there can be no committee amendments. And therefore, we proceed with individual amendments. May I move, Mr. President, that in the period of amendments, the rules be suspended in order to allow the committee to introduce committee amendments so that we can have a better appreciation of how the bill will look like with the amendments submitted by the committee. Otherwise, Mr. President, if we proceed with the individual amendments, this we will find it very difficult and would hardly understand what the bill is all about. So
All right.
that is, if it's in order, Mr. President, I would so move.
All right, with the concurrence of, or with the approval of the members, we may do so. So your motion may be approved by the body. Technically, it is the individual amendment of the sponsor. But given the manifestation that you have placed on record, then therefore I don't see any problem at all.
Yes, Mr.
So
President,
if there's
there
no
being
objection,
Yes.
there is no objection, then the motion of the
Motion is
minority leader is approved.
Thank you, Mr. President.
We will recognize
Would like
Senator
to-
Lacson during the period of amendments.
We'd like to ask Senator Lacson, would he ask for another day?
I
to
concur,
prepare-
Mr. President.
Thank you, Mr.
It will be
President.
a privilege.
Are you ready, sir, to open the period of amendments, or not yet?
Not yet, Mr. President.
Okay,
We have
Mr.
to consolidate and review the interpellation.
Actually, that makes a lot of sense, Mr. President. Then therefore, he can, all the discussions that he had on the floor, incorporate it into amendments, and we will have a proper flow of the amendments from page 1 to the last page. Unlike if individually, we all provide our amendments, ang mangyari niyan, Mr. President, magkakagulo tayo back to page 1 every time somebody stands up. So
No,
that
of
makes
course,
sense, Mr. President.
it will become a new working draft
Yes, Mr.
from the
President, that's correct.
from the sponsor.
That's correct, Mr. President.
Correct.
So
All right.
while we're waiting for the committee amendments, Mr. President, we move to suspend consideration of Senate Bill number 1083.
Any objection? Hearing none, consideration of measures suspended.
Thank you, Mr. President. Mr. President, I move that we consider, with the permission of the body, Senate Bill number 1240. I so move.
Any objection? Hearing none, consideration of 1240 is in order.
We are now in the period of amendments, no? That we close the period of interpellation. Oh, no, I'm sorry. We are supposed to be, we still have one more interpellator, but I believe Senator Bong Revilla has agreed to no longer interpellate, Mr. President, and just provide amendments to this measure. Therefore, we thank the good senator for that. Therefore, we move to close the period of interpellation. I so move.
Any objection? Hearing none, period of interpellation is closed.
May we recognize the sponsor, Mr. President, Senator Aquilino Coco Pimentel III, for his amendments, committee amendments. I so move.
Senator Aquilino Coco Pimentel III is recognized for the period of amendments.
No, Bamboo Bill.
Yes.
Actually, Mr. President, we are still in the period for interpellation. So,
No, we
my
closed it
motion
already.
is to, if we can close it, give
It's closed already.
close
We already closed it, yes.
So, before I proceed, I'd like to manifest the request of Senators Revilla and Binay to be recorded as co-authors of the measure, Mr. President. Including Senator Gordon, Mr. President.
All right, we place it on record.
And Senator Drilon, because he's a proponent of bamboo.
How about the bamboo guy from
Bamboo guy
Iloilo?
provides us bamboo trays.
They are originally co-authors already, Mr. Yes, Senator
Ah,
Subiri,
oh, is he really
Senator
the
Drilon,
author
Senator
already,
Villar. Yes, are authors, original authors.
Original co-author pala eh.
Mr. President,
Yes.
for the record, this is the beautiful bamboo trays from Iloilo, made by the Carmelite missionaries, gifted to us by the distinguished minority floor leader. Very beautiful,
All right,
very beautiful.
thank you again.
Tama na, maganda naman eh. Maganda naman, maganda naman.
So I stand corrected, Mr. President. We include the Senator Drilon as a co-author.
All right, thank you.
So at this point, Mr. President, there are 9, at least not less than 9 proposed amendments. We have not yet finalized the exact wording of the 9,
I
Mr.
see.
President. So if we
Okay.
can schedule this for tomorrow,
Yes.
we will be ready by tomorrow. Mr.
Majority Leader, the sponsor is requesting for a postponement for tomorrow of on the period of amendments.
Okay, Mr. President, yes, I believe the distinguished sponsor was approached by the chairman of the Committee on Agriculture, Senator Cynthia Villar, in the lounge to include certain amendments, to include programs on the measure. So I believe the good gentleman will still have to review that and probably be able to propose tomorrow.
I will be proposing 9 individual amendments, but the authorship can be traced back to 4 of them from the minority leader, 4 from Senator Villar, and then 1 is a joint amendment by Senators Binay and Revilla. That's the case, Mr. President. So, bottom line is, can we schedule this for tomorrow?
Yes, absolutely.
Thank you, sir.
Right now, Mr. President, you're the only one in the agenda tomorrow until our other committee chairmen can come up with their committee reports. Wala na tayong topic. May I make an appeal to my colleagues to fast track their committee reports?
Hasten the
Their
committee report.
committee reports, yes. Oh, choke allowance bukas? Choke allowance bukas, okay.
And Majority Leader, excuse me.
Yes,
Senator Villanueva also requested to be co-author.
Again,
Senator Tolentino has also
all right.
manifested.
Place on record.
Thank you, Mr. President.
Thank you. With that, Mr. President, we move to suspend consideration of Senate Bill number 1240. I believe,
Any objection? Hearing none, consideration of the measure suspended.
just administrative matters, Mr. President. With the consent of the body, after consulting the chairpersons of the concerned committees, I move to transfer the referral of Senate Bill number 1138. This is an act strengthening local government participation in agriculture development by institutionalizing a 10% budgetary allocation from their era from the Committee on Local Government to the Committee on Agriculture as primary committee, and Committee on Local Government will become secondary committee. I believe the chairman of the Committee on Local Government agrees to the change of referral, Mr. President.
All right, we place it on record.
Thank you, Mr. President. There's an additional reference of business, Mr. President. It's a short list.
Yes, the secretary will proceed with the second additional reference of business.
Second additional reference of business, resolutions. PS Resolution number 310 entitled Resolution Creating a Select Oversight Committee on Intelligence and Confidential Funds, Programs, and Activities, introduced by Senator Soto III and Lacson.
Referred to the Committee on Rules.
PS Resolution number 311, resolution directing the proper Senate committee to conduct an inquiry in aid of legislation and within the context of the Program for International Student Assessment Results in order for the Senate to align its legislative initiatives and budgetary priorities with the vision of the Department of Education as it pivots its focus from access to quality in the basic education sector and to sustain the bold efforts of other stakeholders to improve the education system and make it instrumental to developing the country's human capital and serve as a major catalyst to national development, introduced by Senator Gatchalian.
Referred to the Committee on Basic Education.
PS Resolution number 312, resolution expressing the sense of the Senate for the President to reconsider his plan to unilaterally withdraw from the Visiting Forces Agreement with the United States of America, introduced by Senator Soto III, Lacson, and Drilon.
Referred to the Committees on Foreign Relations and the Committee on National Defense. Majority Leader.
With that, Mr. President, there being no other matters to take up today, I move that we adjourn the session until 3 o'clock in the afternoon of Tuesday, February 4, 2020.
Any objection? Hearing none, session is adjourned until 3 o'clock in the afternoon of Tuesday, February 4, 2020.